For Crema Media's Polity, I'm Sane Dlamini. Jean Meiring joins me to discuss the book he edited titled South Africa's Constitution at 21. Welcome, Jean.
Thank you.
Thanks. So tell us about this book and who should be reading it.
Yes, well, it's a book for a general audience. In other words, not for a specifically lawyerly or legally trained audience. The thought was that at the juncture at which the Constitution celebrates its 21st birthday, but also, frankly, in light of the proliferation of litigation concerning rights in the Constitution, the general public is actually engaged by rights in the Constitution every day in the newspapers they read. And in other words, there's a sort of level at which something even as complicated as the Constitution ought to be able to be discussed by people who aren't lawyers. And frankly, and it's a point made somewhere in passing in the book, increasingly every South African is a constitutional expert of sorts, simply because these are issues that all of us think about. Okay. And so to answer your question specifically, it's for really everyone. It's not aimed at lawyers or political scientists or anyone like that.
And our Constitution is well respected at home and abroad. What makes it unique?
Well, it is, I think, widely respected. What makes it unique? Well, I think it was probably it's probably the constitution in the world that has been the most successful in the wake of a process of sort of reconciliation. A lot of the constitutions in the world either have existed for many centuries, like, for instance, the unwritten constitution in Britain, but ours, I mean, perhaps in a sense, Germany's one also came in the wake of much turmoil, the Second World War. But ours was unique in the sense that it went through, essentially it's the product of a process of nation building, of trying to redress the sort of colonial past of the country. So in other words, it's the product of a process of reconciliation. So in other words, inevitably it's a document that represents a compromise of sorts. I guess every constitution does, but ours notably so. And some of the critique, of course, some of the criticism levelled in some of the essays in this book really are, in a sense, criticisms of things that were perhaps forestalled from that writer's point of view, and there are these arguments made both from the right and from the left, and forestalled really because the Constitution was a product of a process of reconciliation.
In chapter 8 by Dan Roth, he discusses that the dark side of our Constitution. And why do you think he is referring to it as the dark side?
Well, he's known to be critical of the South African project. He's on the right of the political spectrum, and he feels that white South Africans have been, or rather were, sold down the river. So he's got views that are happily not shared perhaps that widely in society. So he simply thinks that, and he, in the essay in chapter 8, he throws it over the he casts it in the form of arguments over, most notably perhaps, language rights. So he essentially argues that in a place like Canada, minority language rights are protected better than in South Africa. And I mean, that's his point of departure. He's mostly concerned about sort of minority cultural rights, specifically of Afrikaner people. So, I mean, that's why I think he has that perspective.
Okay. And in chapter 12, Ranjeni Munsami, she refers to our president as the innocent dope who has always been able to manipulate our Constitution. As someone from the law background, why do you think our president has been getting away with this?
Well, firstly, perhaps by way of context, she derives this notion of the innocent dupe from his own trial under apartheid, Zuma's own trial under apartheid many years ago, the papers of which she unearthed. And yes, so she draws that through to how he has conducted himself more recently. Well, in a sense, perhaps the extent to which politicians like President Zuma have managed to use the constitution and the rights accorded to litigants to delay matters coming to court. Perhaps that is inherent in that is some sort of critique on the system that has come into place in our country post-apartheid. But it's a necessary evil. It's a necessary evil if we want the rule of law, if we want a society that isn't premised upon the curtailment of rights, as was the case under apartheid, then we've got to give accord litigants the right to take whatever legal points they might to keep themselves out of prison, out of the reach of the long arm of the law. But it's the system we have, and in a sense, I think it is, well, one of the commentators in the book says that the Constitution, perhaps its biggest failing is that it was designed with sort of Mandela in mind as the sort of archetypal politician. And politicians aren't all like that.
And in chapter 13, BLF leader now, Andile Mqitama, he says the foundation of our Constitution are anti-black, because it gives legitimacy to colonial land theft. And he says our Constitution is just a document of surrender and not liberation. Do you know why is he saying that?
Well, he says that, and having read the essay, you will see he traces it back to responses to the colonial settlers several centuries ago amongst the Xhosa people. And he essentially says that the point of departure for the Constitution, the foundation stone of the Constitution, was the acknowledgement of land rights of those who bore them, who had them at the time of the transition. And that point of departure meant that there was no unravelling of those rights, whether those rights were questionable. It simply, the Constitution departed from the premise that those rights ought to be protected. And he quibbles with that. He doesn't agree with that. He says that essentially validates colonial era theft. And his project is one that questions that assumption. Well, not only questions it, but actually contends that it is flawed. He wants to go back and interrogate the rights that whites and others in power, but really whites, white capital, the rights that they acquired to land and to wealth in the colonial era.
Would you agree with Jackie Dugard, who said the land remains a thorny issue in our country?
Of course it does. Of course it does. I mean, there's so much evidence that is the case. If one looks at what happened in Zimbabwe, I mean, many years after an attempt, a quite concerted attempt had been made to redress the land issue in an incursive and strong way. Zimbabwe appears still to be struggling with that problem, and in our country, yes, of course. If you look at and perhaps the essay by Mxolisi Makubo, the architect, speaks to a similar theme, and that is that the sort of spatial configuration of South Africa. He speaks about the city of Johannesburg. Spatially, geographically, it is still essentially white people living in the centre, and the black people living at something of a remove in townships, and that affects every aspect of the lives of those different groups. So one only has to look at how our cities are configured to know that of course it remains a problem. And of course the difficulty is how, and today is a day that many people in the country are memorializing, commemorating farmers who were killed. Of course, the flip side of the coin is that we have a agricultural sector in the country that is obviously, from the perspective of food security, also very, very important. So, yes, there obviously needs to occur some sort of redress of the land imbalance, but obviously it can't destroy or decimate our agricultural sector. So it's a very fraught, difficult issue, and I'd agree with you. Of course, it's something that still remains an intractable problem.
And what would you say maybe stood out for you while you were editing this book?
Well, two of the really enjoyable experiences were having a conversation with the two ex-constitutional court judges, Judge Krichler and Judge Mokgoro. Both of them came to sitting on the Constitutional Court from very different backgrounds. Judge Krichler, of course, had been an advocate, a High Court and then a Supreme Court of Appeal judge. Judge Mokgoro was a black woman at the time when the transition occurred. So as a black person, of course, she couldn't have been a judge. And as a woman, it was very unlikely that even if she had been white, that she might have been a judge. So, and they both speak in very interesting ways, I think, to their very personal experiences in being on the first Constitutional Court bench, coming from these very different backgrounds. So it was a wonderful experience to speak with both of them and to hear, in a sense, a bit about the nuts and bolts of how was it to sit on this new court. That emerged for the first time in shortly after the transition, first adjudicating the rights framed in the interim constitution and from 1996 in the final constitution.
And what would you say to people who are still saying that maybe former President Nelson Mandela sold out blacks while they were negotiating the constitution?
What would I say to them? It's a difficult one, and as someone who is white, perhaps even doubly difficult. I think that whatever the rights that are framed in the Constitution, I do think certainly I can understand if there is a body of black people, people that were previously disadvantaged, to say not enough has changed, because the reality is that many black people still live in abject poverty and still live in, to put it mildly, the less than ideal circumstances in townships. Whether that is a product of the Constitution, the manner in which it was framed and the rights framed in it, or whether it was or is the product of other political forces, is not for me to say. But clearly there's more could have been done. Personally, for my own part, I'm not sure that it's as such the Constitution's fault.
And would you say maybe if you look at the Constitution, are there any aspect that maybe you think could be improved?
Well, again, despite having edited the book and with a background in legal history, being interested in this sort of part of South African legal history, I'm not myself, in fact, a constitutional lawyer. I do some constitutional law, some administrative law, and in that context touch upon constitutional law, but I'm not actually at the bar, I'm not actually a constitutional practitioner as such. But be that as it may, I think perhaps one of the, for my own part, one of the aspects of the Constitution that I think might require some reconsideration is the party list system, the electoral system premised upon party lists rather than on constituency-based voting blocks. Why? Because I think it creates a distance between the electorate and their elected representatives. Of course, before under apartheid, we had the constituency or the Westminster system, and of course there's certain flaws in it as well. It's by no means a panacea, it's by no means a perfect system, but certainly what it does achieve is to create a more immediate connection between a specifically elected representative and the voters who voted for him or her. And arguably we suffer some of the ills of the remove that the party list system inevitably creates between the elected representatives and those who voted for him or her.
Thank you very much, Jan, for your time. That was Jan Meiring speaking to Crima Media's Polity about his book titled South Africa's Constitution at 21.